Before we begin, it is crucial to understand that this presentation is for informational purposes only and does not constitute legal advice. The divorce process is highly specific to your state and individual circumstances. You should consult with a qualified attorney in your jurisdiction for advice on your specific situation. The words are spoken, maybe over a cold dinner table, maybe in a therapist's office, or maybe they arrive in a sterile email. I want a divorce. And in that single second, the life you knew shatters. Your first feeling isn't even sadness. It's pure, cold panic. A tidal wave of questions crashes over you. What do I do right now? Who do I call? Do I need a lawyer? Can I afford a lawyer? What happens to the house? The kids? The dog? My retirement account? My entire future feels like a blank, terrifying map with no roads. This is the moment where the single biggest mistake in any divorce is made. It's not about fighting too much or not fighting enough. It's not even about hiring the wrong lawyer. The biggest mistake is trying to play a game without knowing the rules. And divorce, make no mistake, is a game. It's a game with complex rules, unfamiliar language, and very, very high stakes. Playing it based on emotion, assumptions, or advice from your well-meaning cousin is like walking onto a chessboard and randomly moving pieces, hoping for the best. You will lose. You'll lose money, you'll lose time, and you could lose what matters most to you. This video is the rulebook you are desperately looking for. This is your 2025 to 2026 guide to the United States divorce process. My goal is to turn that terrifying blank map into a clear step-by-step GPS. We are going to demystify the entire journey, from the moment one person decides it's over all the way to the final signature on the decree. You will learn the vocabulary the lawyers use. You will understand the critical difference between separation and divorce. You will discover the 5 types of divorce and figure out which one is right for you, potentially saving you tens of thousands of dollars. We will cover filing the petition, financial discovery, child custody, alimony, dividing assets, and the crucial art of negotiation versus litigation. By the end of this guide, you won't just know what happens in a divorce. You will understand why it happens, and you will be equipped to make smart, strategic decisions for yourself and your family, instead of panicked, emotional ones. You'll be able to speak to an attorney with confidence, protect your assets, and navigate this process with your dignity and your sanity intact. This is not just about ending a marriage. It's about successfully beginning the next chapter of your life. So take a deep breath. The panic stops now. Your roadmap starts here. The first, most critical phase of this journey doesn't happen in a courtroom. It doesn't even happen in a lawyer's office. It happens right now, in the quiet, in the moments before the first shot is ever fired. This is the intelligence gathering phase, and what you do here can determine the entire trajectory of your divorce. The biggest mistake people make isn't choosing the wrong lawyer or saying the wrong thing to their spouse. It's failing to prepare before the storm hits. Once the word divorce is spoken, the drawbridge goes up. Access to information, to documents, to financial records, it can all vanish overnight. Your spouse, who you once shared everything with, may suddenly become an adversary who sees every shared password and joint account as a liability. So right now, before anything else, you become a quiet, methodical archivist of your own life. Your first mission is to conduct a financial deep dive. You need to get copies. Digital copies are best, but physical copies work, of everything. And I mean everything. We're talking about the last 3 to 5 years of joint and individual tax returns. These are the Rosetta Stone of your financial life. They show reported income, investments, and business interests. Next, you need at least 12 months of bank statements for every single account you both hold, joint or separate. Checking, savings, money market accounts, everything. These statements tell a story about spending habits, income deposits, and regular payments that you might not even be aware of. The same goes for credit card statements. Get a full year's worth. They can reveal hidden expenses, travel you didn't know about, or even assets you didn't know existed. Then you move to the big-ticket items. Gather all documents related to your home. The deed, the mortgage statements, property tax bills, and any records of home equity lines of credit. If you rent, get a copy of the lease. Collect the most recent statements for all retirement accounts, 401(k)s, IRAs, pensions, SEPs. These are often the largest assets in a marriage besides the house, and you need a clear picture of their value. Gather all investment account statements, brokerage accounts, stock options, mutual funds. Get the declaration pages for all insurance policies, life, health, auto, and homeowners. These often have cash values or list beneficiaries that are relevant. And don't forget about loans. Car loans, student loans, personal loans. You need to know the full extent of your shared debt. This sounds like a mountain of paperwork, and it is. But think of it this way. You are building the factual foundation for your entire case. Your lawyer will eventually ask for all of this. By having it ready, you are saving yourself thousands, potentially tens of thousands of dollars in legal fees. You're preventing your lawyer from having to spend expensive hours hunting this down through formal legal requests, a process called discovery, which can be slow and contentious. You are taking control. Create a secure digital folder on a cloud service that only you can access, not a shared family computer, and start scanning and saving these documents. Give them clear names like 2024 Chase Bank Statement January or 2023 Federal Tax Return. This organizational work is the single most valuable thing you can do for yourself right now. Next, let's talk about the digital world. Your digital life needs a security audit, and it needs it yesterday. Start by creating a brand new email address with a strong, unique password that your spouse could never guess. This new email will be your dedicated communication channel for your lawyer, and for any new accounts you set up. It is your private headquarters. Then systematically go through all your important existing accounts, your primary email, your social media, your personal online banking, and change the passwords. Again, use passwords your spouse wouldn't know. The goal here is not to hide anything illicit. It's to create a confidential space to communicate with your legal counsel and manage your own affairs without being monitored. This is crucial for attorney-client privilege. A word of caution here. This is about protecting your privacy, not about engaging in espionage. Do not use your newfound security to spy on your spouse. Do not install tracking software on their phone or use their password to access their private email. Not only is this a profound violation of trust that can make an amicable settlement impossible, but in many states, it is illegal and can result in severe legal penalties. Evidence obtained illegally is often thrown out of court and can make you look vindictive and untrustworthy to a judge. Your job is to secure your perimeter, not to breach theirs. Now, let's talk about money in the immediate sense. One of the most common questions is, should I open my own bank account? The answer is almost always yes, but it must be done correctly. You need a checking and savings account in your name only. This will be your financial landing pad. It's where your paycheck will go once you separate, and it's how you'll pay your bills without having to ask for permission. However, how you fund this account is critical. Do not, under any circumstances, go to your joint bank account and withdraw all the money in a panic. This is called dissipation of assets, and judges absolutely hate it. It looks like you're trying to steal the marital estate and leave your spouse high and dry. The proper way to do this is to take a reasonable amount, typically no more than half of what's in a joint account, and transfer it to your new individual account. You need to be able to justify this amount as necessary for your living expenses and to retain an attorney. Keep a meticulous record of this transfer. Be prepared to account for every dollar. This isn't about hiding money. It's about establishing financial independence and ensuring you have the liquid funds to navigate the initial stages of the process. You are creating a war chest for your own survival, not launching a financial attack. With your documents gathered and your digital and financial life secured, it's time to think about professional help. You need to find a family law attorney. Notice I said find, not hire. Your first step is to schedule consultations with at least 3 different lawyers. Most family law attorneys offer a free or low-cost initial consultation. This is your interview process. You are the one doing the hiring. You're looking for 2 things: competence and compatibility. Are they experienced in your specific type of situation? Do they primarily handle cases in your county so they know the local judges and opposing lawyers? That's competence. But just as important is compatibility. Do you feel heard? Do they explain things in a way you understand? Do you trust their judgment and feel like they will be a true advocate for you? Go into these meetings prepared. Bring a summary of your financial information and a list of your main questions and goals. Ask them direct questions. What is your strategy for a case like mine? How do you prefer to communicate with clients? What is your retainer fee and what is your hourly rate? Who else in your office will be working on my case? A good lawyer will be able to answer these questions clearly and will manage your expectations about the process, the timeline, and the potential costs. Avoid any lawyer who promises you a specific outcome or who seems more interested in fighting than in finding a resolution. Your goal is to find a strategic partner, not a hired gun who will burn through your life savings on pointless battles. This preliminary work gathering documents, securing your privacy, establishing financial independence, and interviewing potential counsel, is your foundation. It puts you in a position of knowledge and strength before the divorce process officially begins. You're no longer reacting to a crisis, you're executing a well-thought-out plan. You've taken the panic and chaos of the unknown and replaced it with the calm and clarity of preparation. Now that you have your armor and your intelligence, you're ready to decide how you want to approach the separation itself. This is the next critical fork in the road, because you don't just file for divorce, you choose a path. And that path will determine if this process is a relatively straightforward negotiation or an all-out war. It's the single biggest factor that will determine whether your divorce costs $5,000 or $500,000. So what are these paths? Think of them as 4 different roads leading to the same destination. The destination is a final divorce decree, a legal document that says you are no longer married. But the road you take determines the scenery, the toll fees, and how many potholes you hit along the way. The 4 main paths are uncontested divorce, mediation, collaborative divorce, and litigation. Let's start with the smoothest, fastest, and cheapest road, the uncontested divorce. This is the unicorn of the divorce world. It's also sometimes called a kitchen table divorce. Why? Because it's for the couple who can literally sit down at their kitchen table with a cup of coffee and work out every single detail themselves. They agree on everything. And I mean everything. Who gets the house? How do we split the retirement accounts? Who gets the dog? What's the parenting schedule for the kids? Who pays what in child support and for how long? If you and your spouse can answer every single one of those questions, and 100 others without a single argument, then you might be a candidate for an uncontested divorce. You've already done the hard work. You've done the negotiating. All you need the legal system for is to basically rubber stamp your agreement and make it official. The process is incredibly straightforward. You or your spouse will file a petition for divorce, and along with it, you'll file a fully executed marital settlement agreement. This is the document you two created that outlines all the terms of your split. Since there are no disagreements, there's no need for hearings, no need for discovery, no need for a judge to make any decisions for you. You've retained all the power. After a mandatory waiting period, which varies by state, a judge will review your paperwork, make sure it's fair and complies with state law, and if it does, they'll sign the final decree. That's it. You're divorced. The cost? This is the best part. Because you're not paying lawyers to negotiate for hours on end, the cost is minimal. You're looking at court filing fees and maybe the cost of having one attorney draft or review your settlement agreement to make sure the language is legally sound. We're talking hundreds of dollars, maybe a couple thousand at most, not tens of thousands. But here's the catch. And it's a big one. An uncontested divorce requires a level of communication, trust, and emotional maturity that, frankly, most divorcing couples just don't have. If there is any history of domestic violence, financial deception, or a significant power imbalance, this path is not for you. It's built on a foundation of complete transparency. If one person is hiding assets or bullying the other into an unfair agreement, the system can be exploited. It's the express lane, but it has no guardrails. So what if you're close but not quite there? What if you agree on most things, but you're stuck on 1 or 2 key issues like the exact amount of spousal support or the holiday parenting schedule? You're still communicating, you're still trying to be amicable, but you've hit a roadblock. This is where you enter the second path. Mediation. Think of a mediator as a neutral third party, a professional referee. Their job is not to make decisions for you. They don't have that power. Their only job is to help you and your spouse communicate more effectively, so you can make the decisions yourselves. They are trained in conflict resolution and family law. They'll sit with both of you in a room, or increasingly in a virtual video conference, and guide the conversation. The mediator helps you identify the issues you need to resolve, brainstorm potential solutions, and find common ground. They can offer insights into what a judge might decide if you went to court, which often helps bring people back to reality. Let's say you're arguing over the house. A mediator might say, okay, let's explore 3 options. Option A. You sell the house and split the proceeds. Option B. One of you buys the other out. Option C. You co-own the house for a period of time until the kids are older. Let's talk through the pros and cons of each one for your specific family. The beauty of mediation is that it's confidential, and it keeps you in control. Nothing you say in mediation can be used against you in court. It's a safe space to negotiate, and at the end of the day, you and your spouse still have the final say. The The mediator doesn't impose a solution. If you reach an agreement, the mediator or an attorney will draft it into that same marital settlement agreement, which you then submit to the court. Cost-wise, mediation is the next step up from uncontested. You're paying the mediator's hourly rate, which is typically split between you and your spouse. The total cost depends entirely on how many sessions it takes to resolve everything. It could be a few $1,000s, or it could be $10,000 or more if your issues are complex. It's more expensive than the kitchen table, but it's still a world away from the cost of a court battle. The catch with mediation? It only works if both parties participate in good faith. If one person is just there to stall, to gather information, or has no genuine intention of compromising, it's a complete waste of time and money. The mediator can't force anyone to be reasonable. If you reach an impasse and one person digs in their heels, the process breaks down, and you're right back where you started, only poorer. This leads us to our third path, a sort of hybrid model that's gained a lot of popularity: collaborative divorce. This is for the couple who knows they need help, they know they can't do it on their own, but they are both absolutely 100% committed to staying out of court. In a collaborative divorce, both you and your spouse each hire your own specially trained collaborative attorney. This is key, they have to be trained in the collaborative process. Right at the beginning, all four of you, your spouse, and your two attorneys sign a binding contract. This contract is a promise. It says that you will not, under any circumstances, go to court. It says you will be transparent, you will share all financial information voluntarily, and you will work together respectfully to find a solution. And here's the teeth behind that promise. If the process fails, if you can't reach an agreement and one of you decides to go to court after all, both attorneys are legally disqualified from ever representing you again. They have to withdraw. You both have to go out and hire brand new litigation attorneys from scratch. This is a massive financial and emotional incentive to make the process work. It forces everyone, including the lawyers, to be on their best behavior and focus solely on settlement. The collaborative process also brings in other professionals as needed. You might have a neutral financial specialist who can analyze your assets and help you brainstorm creative ways to divide them. You might have a divorce coach or a child specialist who can help you manage the emotional side of the process and create a parenting plan that's truly in your children's best interest. It's a team-based approach, designed to support the whole family through the transition. The cost is, again, a step up. You're each paying for your own attorney, plus sharing the cost of any neutral experts. A collaborative divorce can easily run into the $10,000 to $25,000 range or more. But the value is that you're buying a structured, supportive process with a built-in safety net, designed to avoid the single most expensive part of any divorce: a court battle. So you have these three paths: uncontested, mediation, collaborative, all built around a common theme: cooperation. They are all forms of what's called alternative dispute resolution. They are designed to give you, the couple, the power to craft your own future. But what happens when cooperation is impossible? What happens when trust has been completely shattered? When one person refuses to negotiate, hides assets, or makes unreasonable demands? What happens when all of these other methods fail? Then you are forced onto the fourth and final path, the one you see in the movies, the one that can turn your life, your finances, and your family upside down. This is the path of litigation. It is the path where you hand over all control of your life to attorneys and a judge in a black robe, and you enter the world of formal court proceedings, of motions and hearings, of depositions and discovery. It is the all-out war. And that is where the real costs, both financial and emotional, begin to skyrocket. Let's talk about what that war looks like. The first major phase of a litigated divorce is a process with a deceptively simple name: discovery. Think of it as the intelligence-gathering operation of your personal war. The entire purpose of discovery is for each side to legally force the other to reveal all relevant information, and I mean all of it. There are no secrets allowed in divorce court. Your finances, your assets, your debts, your communications, your parenting habits, everything is potentially fair game. The court's philosophy is that a fair outcome can only be reached if everyone has the same set of facts. And discovery is how you get those facts, whether your spouse wants to share them or not. This process is primarily accomplished through three powerful and deeply invasive legal tools. The first is called interrogatories. These are, quite simply, written questions that your spouse's attorney sends to your attorney for you to answer. But these aren't casual, "How's your day?" questions. They are formal, pointed, and you must answer them in writing, under oath, under penalty of perjury. This means if you lie, you are committing a crime. A typical set of interrogatories can be dozens, sometimes hundreds of questions long. They will ask you to list every single bank account you have held since the day you were married, every credit card, every piece of real estate you have an interest in, every job you've had, every bonus you've ever received. They might ask, please state the reason for the breakdown of the marriage, including the date, time, and location of any and all instances of marital misconduct you allege. They will ask you to identify every person who has knowledge of those facts. It is a painstaking, soul-crushing process. You and your lawyer will spend hours, sometimes days, digging through old records trying to piece together a financial and personal history you may have long forgotten, all while knowing every word you write will be scrutinized by the person you once planned to grow old with, who is now looking for any inconsistency, any mistake to use against you. The second tool, which goes hand in hand with interrogatories, is the request for production of documents. If interrogatories are the questions, this is the show me the proof phase. This is a formal, legally binding demand for physical and digital copies of documents. And the list can be staggering. We're talking about years of bank statements for every account, years of credit card statements, your last 3 to 5 years of tax returns, both personal and business, pay stubs, deeds to property, vehicle titles, retirement account statements, life insurance policies, loan applications. But in 2025, it goes so much deeper than paper. They will request your emails, your text messages, your direct messages on social media, that picture you posted on Instagram of a lavish dinner, while claiming you had no money for child support? That's now Exhibit A. That angry text you sent in a moment of frustration? Exhibit B. They might request the entire contents of your phone or your laptop. This is where the digital skeletons in the closet are dragged into the light. It's a brutal invasion of privacy, but in the context of a divorce, the court often sees it as necessary. The amount of paper and digital data generated can be overwhelming. It's not uncommon to end up with boxes and boxes of financial records, or terabytes of digital data, that your attorney then has to spend hundreds of dollars an hour meticulously reviewing, searching for hidden assets or evidence of wrongdoing. This is also a stage where a spouse with more financial resources can try to gain an advantage. They can use discovery as a weapon, burying the other party in an avalanche of requests, knowing that each one costs time and money to answer. It's a war of attrition. They hope you'll run out of money or the emotional energy to keep fighting. But the most intense, the most feared part of discovery is the third tool, the deposition. Imagine this: you walk into a sterile conference room at a law firm. On one side of a long mahogany table sits your spouse and their attorney. On the other side sits you and your attorney. In the middle is a court reporter with a stenography machine, ready to type every single word that is spoken. This is a deposition. It is sworn testimony, given under oath, just like you would give in a courtroom. But there is no judge. It's just you and your spouse's lawyer, who for the next several hours has the legal right to ask you almost anything they want. Your attorney is there to object to improper questions, but for the most part, the scope is incredibly broad. They can ask about your finances. Mr. Smith, you testified you only earned $80,000 last year, but your bank statements show deposits of $120,000. Can you please explain that discrepancy? They can ask about your parenting. Ms. Jones, isn't it true that you were out with friends on 3 of the last 5 school nights, leaving your 10-year-old child home alone? They can ask about your personal life, your relationships, your spending habits. They will ask you the same question multiple ways to see if your answer changes. They will be friendly one moment and aggressive the next. Their goal is twofold. First, to gather information and lock you into a story that you can't change later at trial. And second, to see how you hold up under pressure. Are you credible? Do you get angry easily? Do you break down and cry? They are testing you, sizing you up for a potential courtroom battle. A deposition can last for a few hours or it can last for days. It is emotionally and mentally exhausting. Feels like an interrogation because in many ways it is. You walk out of that room feeling exposed, violated, and drained. And you've just paid your attorney thousands of dollars for the privilege of sitting next to you while you endured it. And then it's your spouse's turn. Your lawyer gets to do the exact same thing to them. This entire discovery process, the questions, the documents, the depositions, can take months, sometimes more than a year to complete. It is the single most expensive and time-consuming part of most contested divorces. The legal fees can easily climb into the tens of thousands of dollars, or even hundreds of thousands in complex, high-net-worth cases. It is a grueling, painful process designed to strip away all privacy and lay every single card on the table. But here is the crucial takeaway. As brutal as it is, discovery serves a purpose. Once all the information is out there, once the financial picture is crystal clear and both sides know the strengths and weaknesses of their case, it often forces a moment of clarity. With all the facts exposed, your attorneys can give you a much more realistic prediction of what a judge would likely do at trial. And facing the cold, hard reality of that potential outcome, and the astronomical cost of getting there, is often the very thing that pushes people back to the negotiating table, making a settlement finally possible. But what happens while this year-long process of digging for information is going on? Life doesn't just stop. The mortgage still needs to be paid. The kids still need to be picked up from school. You might not even be living in the same house anymore. Who pays for what? Who sees the children and when? You can't wait a year for a final divorce decree to get answers. The court needs to create rules for the road while the divorce is pending. And that's where the next battle begins. The fight for temporary orders. This is where a judge steps in for the first time, not to end your marriage, but to dictate the terms of your separation. It's where the first real power plays are made, setting a precedent that can shape the entire future of your case. Think of it as the opening skirmish in a long war. The temporary orders hearing is the first time you and your spouse will stand before a judge, and the court will issue a set of rules that you both must live by until the divorce is final. These aren't suggestions, they are legally binding court orders. Violate them and you could face serious consequences, including fines or even jail time. So what exactly do these orders cover? Essentially, they create a temporary rulebook for your separation, addressing the most urgent issues that can't wait for a final trial, which could be months or even years away. The first and often most explosive issue is child custody. The judge will establish a temporary parenting plan. This isn't just about who the kids live with most of the time, it covers everything. Who has them on weekends? Who handles school drop-offs? Which holidays belong to whom? The court will make a temporary decision on both physical custody, where the children reside, and legal custody, which is the right to make major decisions about their health, education, and welfare. For parents terrified of losing their children, this hearing feels like the most important day of their lives because in many ways it is. Next comes the money. The court will almost certainly issue orders for temporary child support and potentially spousal support, also known as alimony. Child support is typically calculated using a state-specific formula that takes into account each parent's income and the amount of time they spend with the children. If you're the higher earner, prepare to write a check. Spousal support is more subjective. The goal of temporary alimony isn't to set a final number, but to maintain the financial status quo as much as possible during the divorce process. If one spouse was a stay-at-home parent with no income, the court will likely order the working spouse to provide financial support to prevent the other from becoming destitute while the case is pending. Then there's the question of the family home. Who gets to stay and who has to pack their bags? This is a brutal decision. The court will grant one party temporary exclusive use and possession of the marital residence. This decision isn't based on who owns the house, but on factors like what's best for the children, maintaining their stability, or in some cases who can afford to pay the mortgage. Being the one ordered to leave the home you built, filled with memories and your belongings, is a profoundly disorienting experience. Finally, the court will address the bills. Who pays the mortgage, the car loans, the health insurance, the credit cards? The judge will allocate these responsibilities to prevent the family's financial life from collapsing. Often, the court will also issue standard automatic temporary restraining orders, or ATROs. These are crucial. They prevent either of you from doing things like selling off marital assets, taking out huge loans, or changing the beneficiaries on life insurance policies. It essentially freezes your financial picture in place to prevent one spouse from draining the bank accounts or running up debt out of spite. Now, here is the most critical piece of information you need to understand about this stage. The word temporary is dangerously misleading. While these orders are technically only in place until a final agreement is reached, they have a powerful, almost gravitational pull on the final outcome. They create what lawyers call status quo. Let's say the judge grants your spouse primary physical custody of the children on a temporary basis. You get them every other weekend. 6 months go by. The kids have adjusted to the new routine. They are doing well in school. When you finally get to mediation or a final trial, your spouse's lawyer is going to stand up and argue, "Your Honor, this arrangement has been working beautifully for half a year. The children are thriving. Why on earth would we disrupt their lives and change it now? It is an incredibly powerful argument. Judges are extremely reluctant to change a situation that appears to be stable and successful for the children. By winning the temporary custody arrangement, your spouse has created a new reality, a new status quo, and the burden is now on you to prove why it should be changed. You are no longer on equal footing. You are fighting an uphill battle against inertia. The same principle applies to the house. If you are the one who moves out, even temporarily, it becomes significantly harder to argue later that you should be the one to get the house in the final settlement. Possession isn't just 9/10 of the law. In a divorce, it's a powerful psychological and strategic advantage. The person who stays in the home maintains that sense of normalcy, while the person who leaves is immediately displaced. This is why the preparation for your temporary orders hearing is absolutely paramount. This is not the time to be passive. You and your attorney must present the most compelling case possible. You'll likely do this through sworn written declarations, your story told under penalty of perjury, and financial documents. You need to gather every scrap of evidence you have. Pay stubs, tax returns, bank statements, and credit card bills are just the start. If you are fighting for custody, you need to prove you are the more stable, involved parent. Create a calendar showing all the times you took the kids to doctor's appointments, attended parent-teacher conferences, or coached their soccer team. Get declarations from teachers, neighbors, or friends who can attest to your parenting skills. Your goal is to paint a picture for a judge who knows nothing about you. A judge who has maybe 15 minutes to review your file before making decisions that will alter the course of your life. And you must understand that from the moment the divorce is filed, you are under a microscope. Your every action can and will be used against you. That trip to Las Vegas you posted on Instagram? It will be Exhibit A in your spouse's argument that you are a reckless spender who shouldn't get spousal support. That angry text message you sent at 2 a.m.? It will be used to paint you as unstable and unfit for primary custody. You have to start acting as if a judge is watching your every move, because in a way they are. Your character is on trial. The judge's decision at this hearing sets the tone for everything that follows. If you get a favorable ruling, you gain tremendous leverage in negotiations. Your spouse knows you have the court's initial approval, making them more likely to settle on terms favorable to you. If you get an unfavorable ruling, you lose that leverage. You're now negotiating from a position of weakness, and your path forward becomes infinitely more difficult and expensive. The temporary orders hearing is where the abstract threat of divorce becomes terrifyingly real. It's where you see your spouse, not as your partner, but as your legal adversary. It's where a stranger in a black robe, with limited information, dictates the immediate future of your family, your finances, and your home. Once those orders are signed, the battle lines are officially drawn. The rules of engagement are set. And now you must prepare for the next and arguably most grueling phase of the war, the process of discovery. This is where both sides are forced to lay all their cards on the table, whether they want to or not. Discovery is the legal term for evidence gathering, but in the context of a divorce, it's better understood as sanctioned, weaponized espionage. It is the phase where the law gives you and your spouse the power to turn each other's lives inside out, to demand answers to questions you'd never dare ask, and to unearth every financial secret, every hidden asset, and every personal indiscretion that could possibly be relevant to the case. And the definition of relevant is incredibly broad. If you think your privacy is sacred, the discovery process will disabuse you of that notion with brutal efficiency. This isn't about politeness. It's about leverage. The more dirt your attorney can dig up, the stronger your negotiating position becomes. This intelligence-gathering operation is conducted using a few key weapons. The first volley is typically a set of written questions called interrogatories. These aren't casual inquiries. They are formal legal questions that you must answer in writing, under oath, under penalty of perjury. Imagine receiving a document, dozens of pages long, with 100 or more questions dissecting every aspect of your life for the entire duration of your marriage. List every employer you have worked for since the date of marriage, including your title, dates of employment, and all forms of compensation. Identify every bank account, investment account, or financial instrument you have held, either individually or jointly, for the past 7 years, and provide the account numbers. State whether you have engaged in an extramarital affair, and if so, provide the name of the individual and the dates of the relationship. Answering these is a soul-crushing, time-consuming ordeal. You and your lawyer will spend hours, maybe days, meticulously crafting your responses. Every answer is a potential landmine. A slight misstatement, a forgotten detail, can be used later to paint you as a liar. Your spouse's lawyer isn't just seeking information. They're looking for inconsistencies. They're trying to catch you in a trap. At the same time, your lawyer is drafting a similar set of questions for your spouse, tailored to expose their financial weaknesses and personal vulnerabilities. It's a painstaking game of chess, played with sworn affidavits and the threat of legal sanctions. But written answers aren't enough. The second and often more overwhelming weapon is the request for production of documents. This is the show me the proof phase. It's a formal demand for physical evidence to back up the answers from the interrogatories. And they will ask for everything. We're talking years of bank statements, credit card bills, pay stubs, tax returns, deeds to property, vehicle titles, loan applications, brokerage statements, retirement account statements, emails, text messages, photographs, anything and everything that can paint a picture of the marital lifestyle and the assets at play. This is where the financial skeletons are truly exhumed. That secret credit card used for business trips? They'll demand the statements. The unexplained cash withdrawals from the joint account? They'll want to know where it went. The money you loaned to your brother that was never paid back? They'll want to see the promissory note. You'll be buried in a mountain of paperwork, a blizzard of PDFs. Many people hire forensic accountants at this stage, financial detectives who can sift through thousands of transactions to find hidden assets, dissipated funds, or evidence of a lifestyle that doesn't match the reported income. It's a process designed to be so exhaustive and so burdensome that it grinds you down. The sheer volume of information requested is a tactic in itself, meant to overwhelm you and hopefully make you miss something, a detail that can be exploited later on. If interrogatories are the written exam and document requests are the open book test, then the deposition is the live, high-stakes oral interrogation. This is for many the single most terrifying part of the divorce process. You will be compelled to sit in a conference room for hours, sometimes for a full day or more. In the room will be you, your attorney, your spouse, their attorney, and a court reporter transcribing every single word you say. Your spouse's attorney will then proceed to grill you under oath. There is no judge present to intervene. The questions can be deeply personal, accusatory, and designed to make you uncomfortable, angry, or confused. They will ask about your parenting. Isn't it true you were out with friends on the night your child had a 103-degree fever? They will attack your financial credibility. You testified that you don't know where the $20,000 from your bonus went, but your bank records show multiple ATM withdrawals near a casino. Can you explain that? They will probe your personal life. You mentioned in a text message to a friend that you were miserable in your marriage. Was that before or after you started having dinner with your coworker? The goal is twofold. First, to gather information and lock you into a story. Anything you say in that deposition can and will be used against you in court. If you change your story later, they will use the transcript to impeach your credibility and make you look like a liar to the judge. Second, it's a psychological test. They want to see how you hold up under pressure. Do you get flustered? Do you lose your temper? Do you contradict yourself? Your attorney will prepare you for this, coaching you to give short, direct answers, to not volunteer information, and to stay calm. But no amount of preparation can fully steel you for the experience of having the person you once built a life with sit across the table stone-faced, while their lawyer methodically tries to dismantle your character, your finances, and your reputation, one question at a time. Finally, there's a more surgical tool called requests for admission. These are simple, direct statements that the other party is forced to either admit or deny. For example, admit that the 2024 Porsche Cayenne was purchased with marital funds. Or admit that you were cohabiting with another person as of January 1, 2025. This isn't about getting a long explanation. It's about forcing a yes or no. The purpose is to narrow down the issues that are actually in dispute. If they admit the Porsche was bought with marital funds, then you don't have to waste time and money proving that fact at trial. It's now an established fact of the case. If they deny something you can easily prove, the court can punish them for it later. It's a way of cutting through the noise and forcing the other side to commit to a position. Taken together, these tools of discovery create a complete and often unflattering mosaic of your marriage. It's an invasive, expensive, and emotionally draining process that can drag on for many months. It's a war of attrition. By the end of it, there are no more secrets. Every dollar has been traced, every claim has been tested, and every piece of leverage has been identified. All the ammunition has been gathered. The financial and personal battlefield has been fully mapped. And with this raw, often painful collection of facts, you are now standing at a critical crossroads. The cards are all on the table face up for everyone to see. The question is, what happens next? What happens next is a choice. Perhaps the single most important choice you will make in this entire process. Because with all the information from the discovery phase laid bare, you and your spouse are standing at a fundamental fork in the road. Down one path lies settlement. Down the other, litigation. Think of it like this. One path leads to a conference room, a place of negotiation, compromise, and shared control. The other path leads to a courtroom, a place of conflict, rules, and ceded control, where a stranger in a black robe will make life-altering decisions for you. Your choice of path will dictate the cost, the duration, and the emotional temperature of the rest of your divorce. Let's talk about the first path, the one that over 95% of divorcing couples in the United States ultimately take in some form, the path of settlement. This is where the real work of untangling your lives begins. Not with a judge, but with each other. It usually starts with informal negotiations. This is the phase where your attorneys, armed with the financial affidavits and discovery documents we just talked about, begin communicating. It's a series of phone calls, emails, and letters. Your lawyer might send a proposal to their lawyer. We propose your client keeps the 401k, and our client keeps the equity in the house. Their lawyer might respond, we reject that offer, but we propose an equal division of both the 401k and the house equity, and in exchange, our client will waive any claim to spousal support. This back and forth can feel slow and frustrating. It's a strategic dance where offers and counteroffers are exchanged. Each side is testing the other's limits, trying to achieve their client's goals while gauging how far the other is willing to fight. This is where having an experienced attorney pays dividends. They've seen this dance 100 times. They know what a reasonable offer looks like, they know when to push, and they know when to hold firm. They act as a critical buffer, translating your emotional wants into legal strategy and filtering out the angry, reactive responses that can derail negotiations in a heartbeat. But what if this lawyer-to-lawyer dance isn't working? What if you're at a stalemate, stuck on one or two major issues? This is when you escalate, not to the courtroom, but to a more structured form of negotiation: mediation. Mediation is one of the most powerful and effective tools in the entire divorce process. Imagine a private conference room. In it are you, your spouse, and both of your attorneys. But there's a fifth person at the table, the mediator. A mediator is a neutral third party, often a retired judge or a highly experienced family law attorney, who has been specially trained in conflict resolution. Their job is not to make decisions for you. They have no power to issue orders. Their one and only goal is to help you and your spouse find a way to agree. A typical mediation session lasts for a half day or a full day. Often you'll start in the same room, where the mediator will lay out the ground rules. Then, you will likely be separated into two different conference rooms. This is called caucusing. The mediator will then shuttle back and forth between the rooms. They'll come into your room and say, okay, let's talk about the house. What is your position? You and your lawyer will explain your ideal outcome. The mediator will listen, ask questions, and maybe even gently challenge your assumptions, a practice known as reality testing. They might say, I understand why you feel you deserve 70% of the equity, but a judge is almost certain to rule for a 50-50 split. Are you prepared to spend $20,000 in legal fees to fight for that, with a very high chance of losing? Then the mediator goes to your spouse's room and does the exact same thing. They are a confidential conduit of information and a neutral voice of reason. They absorb the anger and emotion from both sides and translate the core issues into practical, solvable problems. They can float what-if scenarios without it being a formal offer. What if he agreed to pay for the kid's college tuition in exchange for a larger share of his retirement account? This allows for creative problem-solving that a courtroom simply can't accommodate. The power of mediation is control. You and your spouse, with the guidance of your attorneys and the mediator, are crafting your own future. You're not handing that power over to a judge who has maybe 30 minutes to review your entire life's file before making a ruling. It's confidential, so your private financial and personal details aren't aired in a public courtroom. And it is almost always significantly cheaper and faster than going to trial. For some couples, there's another, even more integrated option called collaborative divorce. This is a very specific process that isn't available or right for everyone. In a collaborative divorce, both you and your spouse hire attorneys who are specially trained in the collaborative process. You all sign a binding agreement that you will not go to court. You agree to work together transparently and respectfully, with the help of your lawyers and often other neutral professionals like a financial planner or a child psychologist, to reach a settlement. The catch? If the process fails and you can't reach an agreement, both you and your spouse have to fire your collaborative attorneys and start all over with new litigation attorneys. This creates an incredibly powerful incentive for everyone involved to stay at the table and find a solution. Whether it's through informal negotiation, mediation, or the collaborative process, the goal is the same: to produce one of the most important documents you will ever sign, the Marital Settlement Agreement, or MSA. The Marital Settlement Agreement is the final contract of your divorce. It is the legally binding blueprint for your separate futures. Once it is signed by you, your spouse, and approved by a judge, its terms become a court order. This document needs to be exhaustive, precise, and unambiguous. A poorly drafted MSA is a ticking time bomb of future conflict and legal fees. So, what goes into this critical document? Everything. First, the division of assets. Every single asset is listed and assigned to one party. The house, the cars, the bank accounts, the investment portfolios, the retirement accounts, the frequent flyer miles, even the living room furniture. It will specify who gets what, and if an asset is to be sold, like the family home, it will detail how the sale will be handled and how the proceeds will be divided. Second, the division of debts. Just like assets, every liability must be assigned. The mortgage, the car loans, the credit card balances, the student loans. The MSA will state clearly who is responsible for paying each debt, protecting you from your ex-spouse's future financial irresponsibility. Third, spousal support or alimony. If applicable, the MSA will define the exact amount of support, the duration, how long it will be paid, and the terms of payment. Will it be a lump sum? Monthly payments? Is it modifiable in the future if someone's income changes? Is it rehabilitative, designed to help one spouse get back on their feet, or permanent? Fourth, and for many most importantly, is the parenting plan. If you have minor children, this is the heart of the MSA. It outlines both legal custody, who makes the major decisions about health, education, and welfare, and physical custody, where the children live and when. It will include a highly detailed visitation schedule, covering regular weeks, holidays, summer vacations, birthdays, and travel. Fifth, child support. Based on state guidelines, the MSA will set the amount of child support, who pays whom, when it's paid, and for how long. It will also detail who is responsible for covering things like health insurance, medical expenses, and extracurricular activities for the children. This document is your new constitution. It's the rulebook you and your ex-spouse will live by for years to come. Getting it right is everything. Reaching an agreement, signing that paper, it's an act of profound closure. It's the moment you officially take back control from the chaos of the divorce process. It's you choosing the conference room over the courtroom, choosing a negotiated peace over a costly war. But what if the treaty room fails? What if one side or both refuses to compromise? That's when you're forced down the other path, the one that leads directly to the courthouse steps. This is the world of litigation. It's a place governed not by compromise, but by rules of civil procedure. It's a world where the goal shifts from finding common ground to gaining a strategic advantage. When you step onto this path, the tone changes instantly. The cooperative emails from the other side cease. All communication now goes through the lawyers, filtered, analyzed, and documented. Every word is chosen with surgical precision because in litigation, words are weapons. The first major phase of this war is called discovery, and it's one of the most misunderstood, grueling, and critically important parts of the entire divorce process. Discovery is the formal process of gathering information and evidence from the other party. If mediation was about voluntarily putting your cards on the table, discovery is about having the legal authority to force the other person to show you their entire hand, their deck, and any cards they might have hidden up their sleeve. This isn't a friendly exchange of information. It's a deep, often invasive, financial and informational colonoscopy. The law says that both sides are entitled to any information that is relevant to the case. And in a divorce, almost everything is considered relevant. Your finances, your parenting, your work, even your social life. The process unfolds through a series of powerful legal tools. The first you'll likely encounter are interrogatories. These are written questions that your spouse's attorney sends to your attorney, which you are legally required to answer in writing, under oath. These aren't simple yes or no questions. We're talking about questions like, list every bank account you have held, jointly or individually, for the past 5 years, including the account number, the institution, and the date it was opened. Or, Identify every person you have had a romantic relationship with during the marriage. Or, provide a detailed accounting of your monthly living expenses, itemized by category. You and your lawyer will spend hours, sometimes days, crafting responses that are truthful and complete, but that don't volunteer damaging information. Feels intrusive because it is. Next comes the request for production of documents. This is the show me the proof part of the process. Your spouse's lawyer will send a list of documents they demand you produce. And the list is exhaustive. Bank statements, credit card statements, tax returns for the last 5 to 7 years, pay stubs, retirement account statements, mortgage documents, business profit and loss sheets, emails, text messages. Anything and everything that can paint a picture of the marital finances in your life. You'll spend weekends digging through file cabinets and downloading years of electronic statements, creating a mountain of paper that represents your financial life. Your spouse is doing the exact same thing. Both legal teams will then spend hundreds of hours sifting through this mountain, looking for inconsistencies, hidden assets, or evidence of wasteful spending. They're looking for the one credit card statement that shows a hotel bill you can't explain, or the bank transfer to an unknown account. This is where financial secrets are unearthed. Then, there's the most dramatic and intimidating part of discovery, the deposition. A deposition is sworn testimony given outside of court. You'll sit in a conference room at a long table. On one side, you and your attorney. On the other, your spouse's attorney. A court reporter will be there, typing every single word that is said, creating an official transcript. Your spouse will likely not be in the room, but their lawyer is there to represent them. For the next several hours, the opposing attorney will question you about every aspect of your life and your marriage. Under oath, they will ask about your finances, your job, your kids, your affair if you had one, your spending habits, your parenting style. They can show you documents like that questionable credit card statement they found, and demand you explain it for the record. The goal of the deposition is threefold. First, to gather facts for their case. Second, to lock you into your story. If you say one thing in a deposition and then try to say something different in court, they will use that transcript to destroy your credibility in front of the judge. And third, they want to see how you perform under pressure. Do you get angry easily? Do you get confused? Are you a credible, sympathetic witness? Or do you come across as deceptive and unlikable? A deposition is a rehearsal for the trial, and your performance can dramatically influence how the other side values your case and whether they will want to face you in a courtroom. It is an absolutely draining and stressful experience. And discovery doesn't just target you and your spouse. If there's a belief that assets are hidden or information is being withheld, lawyers can issue subpoenas to third parties. This is a legal order compelling someone to produce documents or appear for a deposition. They can subpoena your bank for records you forgot to produce. They can subpoena your employer for your personnel file and salary information. They can subpoena the records of a business partner, or even a new significant other if they believe marital assets were transferred to them. The net can be cast very, very wide. While all this is happening, your legal team is fighting battles on another front: pretrial motions. Think of these as mini court cases that happen before the main trial. A motion is simply a formal request for a judge to make a ruling on a specific issue. For example, if your spouse is refusing to turn over their business bank statements, your lawyer will file a motion to compel, asking the judge to order them to produce the documents. If your spouse's lawyer is trying to bring up something that happened 20 years ago and is totally irrelevant, your lawyer might file a motion in limine to ask the judge to prohibit that evidence from being mentioned at trial. Perhaps the most critical pretrial motion is for temporary orders. The divorce process can take a year, 2 years, or even longer. You can't just put your life on hold. Who will live in the house? Who will pay the mortgage? Who will the children live with primarily? How much child support or spousal support should be paid while the case is pending? A motion for temporary orders asks a judge to decide these issues on a temporary basis, creating a status quo that often remains in place until the divorce is final. This hearing is often your first time in front of the judge, and the outcome can set the tone for the entire case. Securing a favorable temporary order for custody or support is a major strategic victory. This entire process, discovery and motions, is incredibly expensive. Every interrogatory, every document request, every hour spent in a deposition, every motion drafted and argued, translates into thousands and often tens of thousands of dollars in legal fees. It's a war of attrition, and sometimes, the person with the deeper pockets tries to use this to their advantage, filing motion after motion to try and drain the other party's resources. It's also an emotional meat grinder. You're being forced to relive every painful moment of your marriage, have your privacy invaded, and have your character attacked, all while trying to parent your children and go to work. The stress is immense. This is the reality of litigation. It's not about fairness or justice in the way you might think. It's about using the rules of procedure to build a case, brick by painful brick, to present to a judge. All of this work, all of this conflict is leading to one single destination: a trial date. And once that date is set by the court, the clock starts ticking louder, and the pressure to either settle the case or prepare for the fight of your life becomes all-consuming. This is the point of no return. The court has now set what's called a scheduling order, a rigid calendar of deadlines that dictates the final sprint to the finish line. And one of the most important dates on that calendar is the pretrial conference. Think of this as the final high-stakes settlement meeting, but this time it's not just in your lawyer's office. This time it's with the judge. You and your spouse, your respective attorneys, will all convene, often in the judge's chambers, a formal wood-paneled room that feels 100 times more serious than any conference room you've been in before. The judge, who has now read summaries from both sides called pretrial memoranda, already has a pretty good idea of your case. They know the sticking points, they know where the assets are, and they've seen the accusations. And their goal, first and foremost, is to get you to settle. Judges, by and large, do not want to try your divorce case. Trials are time-consuming, expensive for the court system, and emotionally draining for everyone involved. The judge will look at both lawyers and often say something to the effect of, "Folks, I have 100 other cases on my docket. Are you telling me you two can't figure this out?" The judge will then often give their informal opinion on the issues. They might turn to your spouse's lawyer and say, "Counselor, your client's request for lifetime alimony is not going to fly in my courtroom. You need to be realistic." Then they might turn to your lawyer and say, "And your client's position on keeping the entire 401k is a non-starter. This is a marital asset." It's a dose of cold, hard reality from the one person whose opinion actually matters. They are essentially showing both sides their cards, giving you a preview of how they might rule if you actually go to trial. This is a powerful, often terrifying moment. The abstract risk of trial suddenly becomes very, very real. For many couples, this is the final push they need. Faced with the judge's stark assessment, they finally find a way to compromise in the hallway outside the judge's chambers. But what if they don't? What if one or both of you are so dug in, so convinced of the righteousness of your position, that even the judge's warning isn't enough? Well, then the judge will lean back, sigh, and say the words that officially signal the war has begun. "Fine. I'll see you at trial." And now the work truly starts. The weeks leading up to a trial are a frantic, all-consuming whirlwind of preparation that will test your sanity and your bank account. Your lawyer's office transforms into a command center. The first order of business is preparing the evidence. Every document you've produced, every text message, every email, every financial statement, every photograph now needs to be organized, labeled, and turned into a formal exhibit. Your legal team will create what's called an exhibit list, a meticulous log of every single piece of paper or digital file you intend to show the judge. These are then compiled into massive multi-volume binders with copies for you, your lawyer, the opposing counsel, the witness stand, and the judge. Seeing the story of your marriage reduced to a stack of numbered documents is a surreal and deeply unsettling experience. Simultaneously, you're preparing your witnesses. This is not like what you see on TV. Your lawyer isn't just going to put your best friend on the stand and hope for the best. They will spend hours, sometimes days, preparing each witness. This involves reviewing their potential testimony, going over the questions your lawyer will ask, and most importantly, preparing them for cross-examination. Your lawyer will play the role of the opposing attorney, peppering your witness with aggressive, tricky questions designed to trip them up, to make them look unreliable, to twist their words. They're stress testing your witnesses to see who can withstand the pressure of the stand and who will crumble. You'll also be preparing your own testimony. You will spend countless hours with your attorney, going over every single detail of your story, from the day you were married to the day you separated. They will grill you, challenge you, and force you to confront the weakest parts of your own case, because you can be certain your spouse's lawyer will. And then there are the expert witnesses. If your case involves complex finances, you'll be meeting with your forensic accountant to finalize their report and prepare them to explain it to a judge who isn't a financial expert. If it's a custody battle, you'll be meeting with the child custody evaluator or a child psychologist to go over their findings. These experts are your hired guns, and their testimony can make or break your case, but they come at a staggering cost. Their final trial preparation and their time in court can cost tens of thousands of dollars alone. While all of this is happening, the lawyers are engaged in their own strategic battle through something called motions in limine. These are legal arguments made to the judge before the trial starts, where each side tries to get certain evidence excluded. For example, your spouse's lawyer might want to bring up a mistake you made 10 years ago that has nothing to do with the finances of the divorce. Your lawyer will file a motion in limine to argue that this evidence is irrelevant and is only being introduced to prejudice the judge against you. The judge will rule on these motions before the first witness is ever called, effectively setting the rules of engagement and deciding which weapons each side is allowed to bring into the courtroom. The financial cost during this phase is astronomical. You're no longer just paying your lawyer for phone calls and emails. You are paying for their undivided attention, and the attention of their entire team, paralegals, associates working around the clock. Your retainer is long gone. You are now funding a small-scale legal war, and the bills that arrive are shocking. It's not uncommon for the pretrial phase alone to cost more than everything that has come before it combined. The emotional toll is even worse. The anxiety is relentless. You're trying to live your life, go to work, take care of your kids, all while this monumental event looms over you. Sleep becomes a luxury. You second-guess every decision you've made. You replay arguments in your head. You worry about what your spouse will say on the stand, what lies they might tell. You worry about your witnesses. You worry about the judge. The pressure is immense, a constant weight on your chest. This is why, even at this late stage, the vast majority of cases, upwards of 95%, still settle before the trial actually begins. The sheer, terrifying reality of what's about to happen is often the ultimate motivator. Frantic negotiations continue, sometimes through late-night phone calls between the lawyers, sometimes in the hallway of the courthouse just minutes before you're scheduled to walk in. This is the courthouse steps settlement. Both sides staring into the abyss of a trial. The cost, the uncertainty, the emotional devastation. Finally decide that a predictable, negotiated peace is better than an unpredictable, bloody war. They pull back from the brink, sign an agreement, and inform a relieved judge that their services will not be needed. But for that small percentage that doesn't settle, for those who can't find a compromise, for those whose cases are so filled with intractable anger or mind-bending complexity that no middle ground exists, they walk through those courtroom doors. And what happens next, inside that room under oath, will change their lives and their families' lives forever. The air in a courtroom is different. It's heavy, still, and smells of old paper and polished wood. When you take your seat at the plaintiff or defendant's table, the world shrinks to the size of that room. Across from you, perhaps only feet away, sits the person you once promised to spend your life with. Now they are your adversary, their lawyer, a stranger paid to dismantle your life's narrative, shuffles papers, avoiding eye contact. Your own lawyer sits beside you, a temporary shield, whispering last-minute instructions. But when the bailiff calls out, "All rise," and the judge sweeps in, a figure in a black robe who holds the entire future of your family in their hands, you have never felt more alone. This is the trial, the final, brutal battleground of divorce. It begins not with a bang, but with a story. Two stories, actually. These are the opening statements. Your lawyer will stand and, speaking directly to the judge, will lay out a roadmap of your case. They will say, "Your Honor, the evidence will show that my client was the primary caregiver," or "The evidence will prove that this asset, a family business, was built entirely through my client's efforts." It's the trailer for the movie the judge is about to watch. It sets the theme, introduces the characters, and promises a specific conclusion. Then, the opposing counsel stands and does the exact same thing, but they paint a completely different picture. They present their own trailer, for a very different movie, where you are not the hero but the villain. And the judge, the sole member of the audience, must decide which film is based on a true story. After the stories are promised, the evidence begins. This is called the case in chief. It's where your lawyer attempts to build your version of reality, brick by painful brick. The primary way they do this is through witness testimony. Your lawyer will call their first witness to the stand. This could be a financial expert, a child psychologist, a friend, a family member, or even you. This process is called direct examination. Your lawyer will ask open-ended questions designed to let the witness tell their story in their own words. Questions like, "What did you observe on the evening of June the 5th? Or, "Can you describe the division of parenting responsibilities in the household?" The goal is to present your narrative in a clear, credible, and sympathetic way. Every word spoken is recorded. Every sigh, every hesitation becomes part of the official record of your life. And this is where documents become characters in your drama. Bank statements, emails, angry text messages sent at 2 in the morning, report cards, photographs from family vacations, they are all introduced one by one. Your lawyer might hold up a credit card statement and ask, "I'm showing you what's been marked as Petitioner's Exhibit A. Do you recognize this document?" Once you say yes, that document is entered into evidence. It is no longer just a piece of paper. It is a fact, a piece of the puzzle the judge will use to reconstruct your marriage and decide how to break it apart. This is the slow, methodical process of proving your case. It can feel tedious, repetitive, and deeply, deeply invasive. Then comes the moment everyone dreads: cross-examination. After your lawyer is finished questioning your witness, the opposing counsel gets their turn. And their objective is the polar opposite. They are not there to tell a story. They are there to tear one down. Cross-examination is a controlled demolition of credibility. The other lawyer will use sharp, pointed, leading questions. Not what happened, but, isn't it true that you were not present at your child's parent-teacher conference? Not, can you explain this expense? But, you spent $500 at a casino on a night you claim to be working late, correct? This is verbal chess played for the highest possible stakes. The lawyer's goal is to expose inconsistencies, to highlight biases, to question the witness's memory, and ultimately, to make them appear untrustworthy in the eyes of the judge. When you are on the stand under cross-examination, it feels like a high-wire act without a net. You are instructed to answer only the question asked. A simple yes or no is often the best reply. But the human desire to explain, to defend yourself, to shout, "That's not the whole story," is immense. Every instinct screams at you to justify your actions, but doing so can open doors the other lawyer will gleefully run through, leading you into traps you never saw coming. Your credibility, your very character, is what's on trial. Throughout this entire ordeal, you'll hear the lawyers shout, "Objection!" Sounds like something from a movie, but it's a critical tool. Objection, hearsay, means a witness is trying to testify about something someone else said outside of court. Objection, leading, means the opposing counsel is putting words in the witness's mouth during direct examination. Each objection is a mini-argument, a legal skirmish where the lawyers debate the rules of evidence before the judge, who acts as the referee, either sustaining the objection, meaning the witness can't answer, or overruling it, forcing them to proceed. And through it all, the judge watches. They listen. They take notes. They are the most important person in the room, yet they often say the least. They are a human being, filtering every piece of testimony, every document, every tear, and every angry denial through their own understanding of the law and their own life experience. They are observing your demeanor. Are you calm or agitated? Are your answers direct or evasive? They are assessing the credibility of every single person who takes the stand. They are not there to be your friend or your therapist. They are there to be a decider of facts. Your job, and your lawyer's job, is to give them the facts you need them to believe, supported by evidence that is more compelling and more believable than the story being told by the other side. This process repeats, witness after witness, exhibit after exhibit. First, your lawyer presents your entire case. All your witnesses, all your evidence. This can take hours or it can take weeks. You will listen as your finances are dissected, your parenting skills are criticized, and the most private moments of your marriage are laid bare for public consumption. Then, once your lawyer rests your case, the roles are reversed. The defense begins their case in chief. Your spouse's lawyer stands up and begins to build their reality, calling their own witnesses to the stand to tell their story. And your lawyer gets to cross-examine them, attempting to poke holes in their narrative just as they did to yours. It is a grueling, exhausting, and emotionally devastating process. It's a war of attrition, where the goal is to see which version of the truth is left standing at the end.